So one of my subscribers recently asked me a question, and that is, what takes precedence, a deed or a trust? Now, folks, in order to understand the relationship between these two instruments, we should understand what they are. So first is a deed. Now, a deed in real estate realm is a written instrument that conveys title to real estate. And inside a deed, the components are, you have to have a grantor and a grantee, a seller and a buyer, consideration, which is a statement of something of value, and you have to have words of granting. Now, also, in general now, you have to have a description of the property. Description of the property can be one of three ways. The first is a reference to a plan that has been recorded at the Registry of Deeds. And if some of these terms are not familiar, make sure that you check out some of the links that I have included in the description below, or if you're watching Facebook, the description above, to further describe some of these concepts. But once again, so a reference to a plan that's been recorded at the Registry of Deeds is the first way. Second way to describe a piece of property on a deed is metes and bounds. And the easy way to explain what metes and bounds is all about is it's just a legal description that explains the perimeter of a lot of land. So basically, you can picture yourself walking the lot line of the property. The third way, which is not used up in the Northeast, where I'm from, is the government survey, which is the grid line system. And that's the way you can reference or describe real estate. Also included in the deed is a signature of the grantor, the seller, in other words, the person conveying title. And so with this document now, that's how you convey title. Now, why do you use a deed? Well, for obvious reasons. If you're selling the property, of course, you're going to create a new deed and transfer title into the name of the buyer. The other area where I often see deeds being used effectively is in estate planning. And in essence, what you can do when you create a new deed in your estate plan is you can create what's called a concurrent tenancy. Now, with a concurrent tenancy, there's more than one person on title. That's all it means. And you can hold title with others. Let's say, for instance, if a couple is married, then you can hold title as tenants by the entirety. And one of the qualifications, of course, is that you must be married. And with a tenancy by the entirety, there is a right of survivorship, which means that if one of the spouses passes away, the other receives 100% of the title by operational law with no judge necessary. Now, the other way that you can hold title in a concurrent way or with another person is with a joint tenancy. And with a joint tenancy, you don't need to be married. So brothers and sisters or brothers can hold title. You can have friends holding title, business partners holding title, lifetime partners holding title, and you can be married as well. And with a joint tenancy, once again, there's a right of survivorship with the joint tenants. So if one of the joint tenants dies, passes away, their interest transfers to the surviving joint tenant by operational law, no judge necessary. And the difference between a tenancy by the entirety and a joint tenancy, once again, you don't need the requirement of marriage, and joint tenancies in general are easier to break, to sell interests. And then the third concurrent tenancy is a tenancy in common. There's no right of survivorship with a tenancy in common. So basically what that means is if one of the title holders passes away, that interest passes down that person's bloodline. So those are the ways you hold title to real estate. And once again, a deed is an instrument that defines the way a person holds real estate. Now in comparison to a trust. Now a trust in general is a fiduciary arrangement. And what fiduciary means, it's an arrangement where a person of a high level of trust is going to be involved. And so the maker, the grantor, the person who creates this written document would then appoint a manager of the trust called a trustee. And assets would be placed inside the trust for the benefit of other people or other individuals. And those would be called the beneficiaries. Now, what do you need to form a trust? Well, once again, you need to have the arrangement where there's a trustee appointed, the trust itself is created, there are terms inside, written terms inside trusts, and the beneficiaries are also designated. Now, there are basically two types of trusts. There's what we call a revocable trust, which is a flexible trust, meaning that the maker or the trustee or the beneficiaries can change the terms of the trust, change the assets that are involved in the trust, or change the people that have been designated inside the trust. So it's very flexible in nature. And then the second type of a trust that can be created is an irrevocable or irrevocable trust. And these are more structured trusts. These types of trusts, the terms are kind of etched in stone. And so when someone creates this type of a trust, it's very hard to change what's there, change the terms inside the trust, or change the people that are involved with the trust. Now, why do people create trusts? Well, there's a whole host of reasons why people create trusts. I often say to my clients, creating a trust is like creating another person, a person that can hold assets. You can actually think of trusts like almost like a yard that's got fences around it, and you can place whatever you want inside that yard. Now, why do people create these types of trusts? Well, one could be ease of management. So if, for instance, there's a family that manages a piece of real estate, they may create a revocable realty trust that is flexible in nature, so it's easy to be managed. Other reasons why people want to create trusts, well, first of all trusts will avoid probate. So anything that is inside a trust, in general, will avoid the probate court. Why do people want to create irrevocable trusts or irrevocable trusts? Well, these are usually used in an estate plan, whether it's Medicaid plan or whether it's a plan to avoid estate taxes. So those are the typical ways that I see irrevocable trusts being formed. So back to the question, what takes precedence, a deed or a trust? Or can a trust override a deed? Well, first of all, let's take a look back in this video and understand what each thing is. The deed transfers title to real estate, and it also designates the tenancy, the way someone holds title to real estate. So it's an instrument that conveys title. A trust is like an instrument that holds things. So you can have a deed, and the short answer to our question is the deed always dictates the way title is held. But there's an exception to the rule. If you create a trust, a realty trust, to hold title to real estate, then you would need to create a deed transferring title into the trust. And in that instance, when you create a deed into trust, as we call it, then the trust will dictate the way the title flows in the event of an occurrence, something triggering the trust to go into place to transfer title. So in that instance, a trust will dictate the way title goes. And it will usually happen outside of the probate court. But remember, you can have a deed and you can have a trust. The trust, as I say to clients, is only a piece of paper. You must fund the trust, and you fund the trust with a deed. And when that happens, then the terms of the trust will apply. If you never do a deed into the trust, then the real estate will sit as the deed sits at that point. Now, if you're watching me on YouTube, make sure that you subscribe in the lower right-hand corner. If you're watching me on Facebook, make sure that you like the video. Be sure to check out some of the links that I've included in the description below, or if you're watching me on Facebook, the description's above. And if you're watching me on YouTube, there will be some other videos appearing here, some of my past videos, and a list related to this topic. So make sure you check those out. Dave Ceruolo, CeruoloLaw.com.